which is it's Latin. It's a motion pendente lite, meaning that you want temporary relief. And in this particular, we'll call it the PDL motion, you want to ask the court to enter into some type of custody schedule, an interim parenting plan, basically until the case is concluded. Now, what the court may do is appoint a guardian ad litem, which we talked about earlier, which is another lawyer licensed in the state of Missouri to practice law, and he or she will represent the best interest of the minor children. And again, this particular person will talk to yourself, will talk to mom, will talk to any other witnesses or other people that you want this particular person to talk to, and then try to mediate between mom and dad and come up with some type of consent parenting plan. If that is not going to be the case, then unfortunately you're going to have a hearing held on your motion, which is similar to a trial, but it won't be as lengthy as a trial. And then the judge will ultimately decide who's going to have primary custody, or if the judge is going to do 50-50 custody and enter into some type of interim parenting plan. Now, I can tell you this, that most judges do not like to hear issues twice. So if the parties can work something out, unless there's some type of egregious acts from one parent towards the other or towards the children, then the court will entertain the actual motion. But if it's just two parents can agree on a parenting plan and cannot meet with the guardian ad litem to do some type of consent interim parenting plan, then the court's going to be upset. And a remedy that the court has is to award fees from one party to the other. So if, in this particular case, if mom is not being that cooperative or refuses to cooperate and enter into some type of reasonable interim parenting plan, and this case has to be, or this issue has to be tried to the court, then what the judge can do is order mom to pay a percentage of dad's attorney's fees. So I would encourage to try to work this out and get a guardian ad litem involved. Now, taking it a step further, if there is supervised visitation, then unfortunately you can get the case tried or have the judge rehear the hearing where the court orders supervised visitation. Then you will have to provide mom either with a list of names that she accepts or a person that she accepts, and then the visitation can only take place with that particular person at the time and the date that was agreed to, either by court order or by the parties themselves. We're going to move on to another one of our questions here, and it states that this particular person's accounts have been frozen, and he indicates that he's been current in his child support, it's just that he has moved from state to state, and apparently under what this question poses here is that the states that he has moved from or back and forth between have not caught up with one another on the child support payments. I would advise you not to stop making child support payments regardless of the situation, because if you had to take this to court and the court sees that you stop paying child support, even if you are correct, that's not going to look good. You want to position yourself to look the best in the eyes of the court. And in this particular case, you're going to want to continue to pay the child support. And what you're going to want to do is file a motion with the court, and you want the court to take a look at what's going on in your case so we can get all the states up to speed on the same page, so you're not showing any type of arrears in child support. And the easiest way really to do that is to go to the clerk of each state in which you lived in which child support was being paid, and ask for a printout of your child support payments. Because if you're paying directly to that particular state or to the Child Support Enforcement Agency, they keep a log basically of when what the payment was, when the payment was received, and they keep it an ongoing tally of what you have paid to date, what is owed, if anything, and if there's been any amendment. So if you can get a clean sheet basically which will state that you're current in your child support payments, get that from the other states and present it to the court, then the court can bring everybody up to speed basically and keep your child support payments as is. But I would recommend not to stop paying child support payments. That just does not look good for you, positions yourself, and it puts yourself in a bad position in the eyes of the court. So continue to pay the child support, but at the same time make sure that you're getting a printout of what you're actually paying so you can take that to the court if and when you choose to file the proper motion with the court. We have another question that states that a divorce was filed on the 13th of November for this year, 2008, and that mom is trading in certain property, in this particular instance, a vehicle that was already paid for and traded in for a minivan, and then now has incurred debt. And this person wants to know if they will be responsible. What you need to do is, one, if you're already in litigation to have an attorney, have your attorney send a subpoena to the car company to where this vehicle was purchased to see if your name was forged. Because one, that could be a conduct that the court can take into consideration in awarding a disproportionate amount of the assets. And so if mom forged your name, not only has she done something criminally, which she could be criminally liable for and prosecuted for, but in the divorce case, the dissolution case, which is a civil action with the court, your civil remedy would be for the court to award a disproportionate amount of the assets, meaning greater share of the assets to you and a greater share of the debt to mom. So that would be the first thing that I would find out. And then also what I would do is send some discovery to mom to find out exactly what is going on. Because if you didn't agree to this, you didn't know about this, then she's just arbitrarily using marital property. She can keep the van if the car that she traded in was hers or something that you didn't want.